Hi, I'm Michael Hughes, and this is Contract Mastery. Paragraph 29 deals with attorney's fees in the event that there is a lawsuit filed that arises from the lease agreement. Then we have a provision as to how the attorney's fees are going to be allocated. The lease agreement has the provision that attempts to deter frivolous lawsuits by requiring that the losing party has to pay the winner's attorneys and legal fees. This is a common provision in contracts in the United States, with the idea being that if a person's going to bring a lawsuit, they are going to want to be sure that they've got a good claim, because if they lose, they're going to end up paying the winner's attorney's fees. The terms of the document here in paragraph 29, any person who is a prevailing party in any legal proceeding brought under or related to the transaction described in this lease is entitled to recover prejudgment interest, attorney's fees, cost of service, and all other costs of the legal proceeding from the non-prevailing party. So again, it is intended to be a deterrence against frivolous lawsuits, with the idea being that because of this provision, this cost-shifting provision, that a person bringing a lawsuit under the lease agreement should be extra sure they've got a valid claim before they proceed. Paragraph 30 of the lease agreement talks about representations, specifically the tenant's representations to the landlord in the lease agreement. The parties to the lease agreement do not sign this document under any oath or any sort of penalty of perjury. So we don't have that. It's not that formal of a document. However, we do make representations. And a representation in a contract is an affirmative statement that is made by one party to the other, and the party receiving the representation is relying on that statement to be true. They're relying on that as they're entering into this agreement with the other side, that what they are saying to them in this representation is actually true. If a statement is represented as being true and correct, but is later found not to be, then sometimes that can be treated as a material breach of the contract, simply because the statement was made as a representation. It was represented to be true, later found not to be true, and then that's treated as a material breach of contract. Paragraph 30 here, the tenant's statements in this lease and any application for rental are material representations. If the tenant makes a misrepresentation in this lease or in an application for rental, then the tenant is in default. Note here they bring in the application as a material representation of the tenant, and the tenant is promising here that everything they said in their application is true and correct. If later on it is found that some of the statements in the tenant's application were not true, at that point the landlord could treat those as misrepresentations, and therefore the tenant is in default under the lease agreement. Paragraph 31 deals with addenda to the rental agreement. This paragraph is going to look familiar to us from our other promulgated contract forms. It's what I call the checkbox paragraph. It's where we add in outside documents that we are saying are going to be part of our lease agreement. Incorporated into this lease are the following addenda, exhibits, and other information. If landlord's rules and regulations are made part of this lease, then the tenant agrees to comply with the rules and regulations, as landlord may, at the landlord's discretion, amend them from time to time. You'll see one of the checkboxes that we have in here is landlord rules and regulations. If we have checked the box, and there is a document called Landlord Rules and Regulations, then those are incorporated into the lease agreement as if we had a whole paragraph saying Landlord Rules and Regulations right here in the lease document. And the tenant is agreeing that they will comply with those rules and regulations as they may be amended from time to time. Take a look at some of the documents that can be incorporated into the lease agreement. The first one, the addendum regarding rental flood disclosure, this should always be checked because the landlord is always required to give this disclosure to the applicant before the lease is signed. If the property was built before 1978, then we're required to provide a lead-based paint addendum. Make sure that you're using the correct version of the lead paint addendum. There is a version specifically for rentals, and there is a separate version of the document that is for a sale or a purchase situation. The form that is specifically geared towards rentals is TXR 2008. If the property does require a lead-based paint addendum, in addition to that addendum, you are also always going to be required to provide the EPA pamphlet, Protect Your Family from Lead in Your Home. Anytime a lead-based paint addendum is required, the EPA requires that this pamphlet be provided to the tenant or the purchaser at the same time. So anytime we have a lead-based paint addendum, we also are going to have this Protect Your Family from Lead in Your Home pamphlet. The inventory and condition form we talked about in a previous video. It should always be included in a residential lease, in my opinion. And tenants agents, make sure you stress to your tenant clients the importance of completing that form, being detailed, and getting it returned on time. A lot of different documents that could be provided here in addition. Additional parking rules. If there is an animal of any kind, then we'll have an animal agreement. Mold remediation, consumer protection document. If we have a guarantee situation where another party is going to be guaranteeing the tenant's performance under the lease, then we'll have to include that document as well. An agreement between brokers. This document is not needed if the rental property is on the MLS and if there is an MLS offer of compensation. But otherwise, this agreement between brokers is a lease commission agreement between the listing broker and the tenant's broker. It is only valid in a lease situation. So make sure you're dealing with the correct document, but it is called agreement between brokers. And in a lease transaction, this is a commission promise from the listing broker to the tenant's broker. The landlord rules and regulations that we talked about previously, this is the box you would check if the landlord does have a rules and regulations document. Other things that we can include, if we want to include a copy of the homeowner association rules, if the property has a pool or a spa, then we're going to have the pool and spa maintenance addendum. The residential lease application should always be checked as part of the rental agreement. That way, if there's any kind of false statements, then we've also included the application as part of the agreement itself. And then we can include a bed bug addendum if the parties desire to have that as part of the rental agreement.